So how does a company work? So last week we had a discussion on whether to run a business, a person needs to have a company and should jump ahead and just register one before any business is established. And then obviously we want to start having conversations around what the tax consequences are, how a company runs, and best practices for companies. But before we go all the way there, let's speak about the ABCs of companies, right? What is a company in South Africa? So a company is recognized as a separate legal entity, a juristic person. This means that it has its own identity, can be recognized separate from the individuals that own the company, and can trade in its own name. However, it does still have shareholders. So a company does have an ownership structure. So at the end of the day, there is somebody at the top of that structure that owns shares in that company. And you may find that there might be several individuals, or with JSE listed companies, for example, thousands and hundreds of thousands of shareholders in a company. So what is a shareholder then? So we have to go all the way and look at the legislation that actually assists and supports the creation and operation of a company. And this in South Africa is called the Companies Act. Now, why is this relevant to you? Because the Companies Act has a lot of information that assists the shareholders and directors of a company to run the company. Now, shareholder is defined as a person that has an interest in the company, and this is called their shares in the company. Now, there can be multiple different types of shares in a company, ordinary shares, preference shares, different classes of shares, and we'll get to that at a later stage. But for now, it's just important to understand that a person or another company or a trust can own shares in a company. Then what is a director? Can the shareholder simply not run the company and make the decisions and deal with the operations of the company? No. In the Companies Act, a director is responsible for the operations of the company. So a director steers the ship, whereas the shareholder simply owns the ship. Director makes sure it goes to the right place and gets done in the right way. Now, very often with small businesses, you find that these are the same individuals. One person would have 100% shares and would simultaneously also be the director or CEO of the company, whatever you want to call it. Sometimes the husband and wife have shares, and simply the husband is the director of the company. Now, bearing in mind that this applies to small businesses, the reason why there's a distinction is because in larger businesses, again, looking at the JSE, not every shareholder could be a director of a JSE listed company. So the directors get appointed as professionals, as a job to run the company, to perform, to reach targets, to bring the company into profitability. The shareholder's role, for the most part, should be simply sitting back and earning dividends. That is it. Sit back and earn dividends. What are dividends? Dividends are basically the profit or income that the company can give to its owners. I receive income, I pay my expenses, I then declare dividends to the owners so they can share in whatever profit that I made. So the shareholders get the dividends. Directors simply run the company. Directors have fiduciary responsibilities to the company and by implication shareholders. What does this mean? The director cannot act against the company, cannot do anything to detriment the company. And if it does, the shareholders can usually step in and remove the director. Now, if the shareholders have so much power, why can't they just run the company like I asked before? Because it's not typically good practice. You want to be able to have that division of people that do the right thing and people that simply want to make profits. It allows the company to actually function properly and create different opportunities. Now, one thing to also bear in mind, again, this happens a lot with small businesses. A shareholder in the Memorandum of Incorporation, which is basically the document that founds the company, creates all the rules and what the company is expected to do and how it's supposed to do it. And this is often, again, dictated by provisions in the Companies Act, but you can have your own. It's basically a set of rules for the company. Now, the thing with this is, if the shareholders agreement or the Memorandum of Incorporation is drafted with too much obligations being given to the shareholders, this unfortunately inhibits the directors from being able to conduct business properly. And another problem with this also is if the shareholder happens to pass away or be declared insolvent, decisions in the company come to a dead standstill. So we also want to make sure that when we set up these rules for the operation of a company, that we don't overburden the shareholders with decision-making powers when in fact a director should have most of the powers except for very, very important things that do not happen on a daily basis, that are exceptional in nature. And this we would put in the Memorandum of Incorporation and or a shareholders agreement. If you understand all these principles and you have those two documents in place, then you're good to run your company as long as these are drafted properly. Please be careful of templates. There are very bad templates out there. The CIPC does issue its own standard form template. I'm not against it, right? It basically is a repetition of everything in the Act. It's very standard form. But if you have multiple shareholders in a company, I would strongly suggest that you just have this reviewed and make sure that it's bespoke to you.